Welcome back. The Venezuelan migrant charged with murdering 22-year-old nursing student Laken Riley on the University of Georgia campus in February has waived his right to a jury trial. Jose Ibarra's bench trial now set to start on Friday. Phil Holloway, former assistant district attorney and former police officer, has been following this case from the start, joining me now to discuss. Phil, this is quite unusual for the defense to make this request.
Oh, yeah, unusual to say the least. And thanks for having me, by the way. Listen, the case against the defendant in this case it's overwhelming. The evidence of guilt is overwhelming. But from the defense perspective, if all you have is a Hail Mary, I don't understand why you give the Hail Mary away. After all, you might find one juror that could perhaps hang this up. Otherwise, he's on a fast track express straight to the state prison. He might even be in prison before Thanksgiving at this rate.
Well, the state even sounded a little bit surprised. Let's play for you what Sheila Ross said today.
The state was contacted by the defense last week, and they let the state know that they wish to waive the defendant's right to a trial by jury, and instead this defendant wishes to seek a trial by judge only, a bench trial.
And the judge checked in with Ibarra to make sure that he knew what that meant. Have you ever seen something like this happen before? And what do you think is the strategy there? Is there one?
I've seen this happen in the context of maybe waiving a jury in exchange for taking, say, the death penalty off the table. But the district attorney in this case, the one who got beat in this last week's election, has already made the determination that the death penalty is not on the table. So this is very unprecedented in my view, and I can't really see any advantage that the defense might have by this. On the other hand, the prosecution gets a big advantage because instead of having to prove their guilt, his guilt to 12 people, they only have to prove it to the judge, and they get to streamline their evidentiary presentation. They don't have to worry about all of the extraneous matters that they might have to deal with if there was a jury in the box. So it makes the prosecutor's job easier. It shortens the trial considerably, and I don't see any discernible benefit for the defense. But one day, these lawyers who represent him, I'm sure they have their reasons. We just don't know what those reasons are. They will explain it whenever there's a motion for a new trial and they have to testify as to what their strategy
real quickly,
Oftentimes, people use the term closure at an event like this, and I acknowledge that there's no such thing as closure. There will not be closure. This is just another stage or event in this tragedy, and that's the way I view that. People mean well by saying that, but it's. I've heard it explained that when you have something like this that impacts one or many, you even have to make a conscious effort to breathe at sometimes. And that just comes on you at any particular, you just don't know what's going to bring it on you. And you realize that you do make it through the day, but you don't know how you did it. But I also, and this goes back to what Kerry Howell was saying, that, as many times as you reflect on the loss, at some point you start smiling about the memories. And I'm hopeful that at some point that takes over to a certain extent.
All right, welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This, of course, is the LawTube channel where we take you inside the real justice system. And look, there is no case that I've been familiar with, and maybe ever, that's as real as the terribly sad case involving the murder of Laken Riley, of course, a 22-year-old nursing student who was killed on the campus of the University of Georgia, something that we've been following here inside the law, and I know lots of you have been as well. Um, I wanted to go ahead and just do this live stream, and for those of you watching, I appreciate it. Please consider liking the video so that others can find it, and those of you who watch it on replay, hopefully we can use this as an opportunity to learn something about what this sentencing means. And in a few minutes, I'm going to dip back into more of the extended video of the actual sentencing of Jose Ibarra. There's been a lot of questions people have had about what's what it means, what the sentencing means, what the way the judge pronounced sentence. What does that mean? Things like merger and parts of the case, the counts that were vacated as an operation of law. So we're going to get into that. But before I do that, a lot of people are asking, why was he not eligible for the death penalty? And the reason is that it's because of the district attorney. The district attorney made a decision not to seek the death penalty, and she paid. Well, she lost her job. She lost an election because of it. She recently was defeated in the November general election. She did not have a. She was a Democrat. There was no Republican on the ballot that ran against her. So, interestingly enough, a guy mounted a write-in campaign, and he beat her soundly with a write-in campaign, something that's just kind of unheard of. I'm going to have Kalki hopefully joining me here, not today, but in another live stream here in the not too distant future to talk about that race and what he might or might not have done differently with respect to this case. But for those of you who are interested in checking out a little bit more, I have an opinion piece that I wrote yesterday and last night. It's been published today on foxnews.com, and it goes into a lot of the details regarding that issue and maybe how it came about. But the bottom line is that in Georgia, the death penalty is only available if the district attorney seeks it. And once the district attorney in any given jurisdiction files a notice of intent to seek the death penalty, there's a lot more procedure and a lot more procedural safeguards that kick in. It's a much more complicated matter from pretrial motions. The defense lawyers have to be what we call death qualified, meaning they have gone through special training to defend those kind of cases. And so it's a much lengthier process, much more involved than what we saw in the bench trial. I still don't completely understand why the defendant waived his right to a jury, but nevertheless, he did just that. The sentencing, though, I mean, the judge only had the option of seeking, or basically imposing life with parole or life without parole. And so I want to just kind of take a minute, and the counts were, there was a number of counts. I've got to look it up. I've got, so we had count one. Counts 1, 2, and 3 were felony murder. Count one was what's called malice murder. That's where you deliberatively intend with malice aforethought, an abandoned and malignant heart, where you intend to do the act in that way. The felony murder, those are alternative ways of charging, where if someone commits a felony and someone dies in the process, whether you intended that death or not, you can be on the hook for murder. And in Georgia, there's only 3 possible sentences. One's death, one's life with parole, one is life without parole. So that's it. There's no other term of years that you can get. But when the DA takes or elects not to seek the death penalty, and by the way, she elected that on day one, not to seek the death penalty. There was a memorandum that she sent her out on the very first day in office where I'm trying to pull this up. I want to give you an exact quote, but she said that this office basically will not, under any circumstances, ever seek the death penalty. And that was in a memorandum that she sent out day one when she took office, January of 2020. And so fast forward to this tragic event involving Laken Riley, and she's, she filed. Nothing could have changed her mind. Not even the callousness and the just the abhorrent nature of this particular case could not change her mind. So anyway, you've got count one was malice. You had the felony murders. There was a count of kidnapping with bodily injury. We'll get back to that in a minute. One count of aggravated assault with intent to R-word. One count of aggravated battery. Aggravated battery is where if you injure someone and you deprive them of the use of a member of their body. Basically, if you commit a battery, an aggravated assault, or a battery with some type of serious physical injury, then you've got aggravated battery. It's maiming, if you will. Obstructing or hindering an emergency telephone call. There was evidence in the case where she had attempted to call 911 from her cell phone, and using his thumb with his thumbprint, he hung up the phone while she was attempting to make the 911 call. There was one count of tampering with evidence. You saw the video if you watched the trial of Ibarra throwing items away. He threw clothing away in the dumpster that had mixed DNA, his and Laken Riley's on it, among other things. And one count of peeping Tom. And what that I think is a misdemeanor, but the reason that was important is there was evidence in the case that he went to another female's apartment and tried to break in around 7 in the morning. He couldn't get in. So what it looked like is that this was when he was not successful with his intended victim, he found another unintended or unplanned, if you will, victim, maybe in a crime of opportunity, and that was Laken Riley as she was jogging that morning. If you ask me, my personal opinion, it's not his first rodeo, not his first time. Look, the evidence was that he woke up in the morning. He posted really early, like 4 or 5 o'clock in the morning. He posted on, I think it was Snapchat or Instagram, something with his clothing, which of course matched what they later saw. And then there was evidence that he even started drinking early, around 7 o'clock in the morning. And it's almost like he was preparing or steeling himself, if you will, to go do this horrible deed. And my personal opinion, it's not his first time, not his first rodeo. I guess we may never know what, if anything, he may have ever done elsewhere, or perhaps even before he came to the United States some years ago. So those are the counts in the indictment. And so the judge, all of these are significant felonies. The murders, of course, are aggravated assault, 20 years in prison that you can get. Aggravated battery is the same. So what I'm going to do is, first off, again, I thank all of you who are here spending some of your late morning or perhaps into your lunch hour with us here inside the law. But I'm going to, I want to pull up the video in the case of the actual sentencing, and I'm going to pause and I'll stop it and start it because I want to explain it. This particular, if I ran it without stopping, it would be a little bit over 5 minutes, but I'm going to pause it to discuss what exactly is going on as it shows in the video.
Sometimes people use the term closure at an event like this, and I acknowledge that there's no such thing as closure. There will not be closure. This is just another stage or event in this tragedy, and that's the way I view that. People mean well by saying that, but it's I've heard it explained that when you have something like this that impacts one or many, you even have to make a conscious effort to breathe at sometimes, and that just comes on you.
So this is not uncommon, and I'll hit play again in a minute. But what you see oftentimes is judges trying to do the best they can to offer some um, words of comfort, but there's really just no way to comfort grieving families and quite frankly the community at large. But the judge is a human being, and this is his opportunity to say kind of what he feels, and that's what's happening. It's just some prefatory remarks, but you can kind of see already how this is going to go.
Any particular, if you just don't know what's going to bring it on you. And you realize that you do make it through the day, but you don't know how you did it. But I also, and this goes back to what Kerry Howell was saying, that, as many times as you reflect on the loss, at some point you start smiling about the memories. And I'm hopeful that at some point that takes over to a certain extent. But there's very little, including the sentence of Mr. Ibarra, that's going to help much, and I acknowledge that. With that, Mr. Ibarra, if you will please stand. Count one, malice murder. I sentence you to life without the possibility of parole. Count two will be vacated as a matter of...
So count one is the malice murder. And so the judge, by the way, in case if you didn't watch this, not that there's anything funny about it, but sort of the running joke was whether or not the judge was actually going to deliberate, or how long was he going to pretend to deliberate? And he essentially, at the end of closing argument, said, "I'll take a 15-minute recess and I'll be back." Just long enough to kind of fill out the verdict form. He already knew what he was going to do. It was absolutely a foregone conclusion. I don't think there was any question in the judge's mind what the appropriate sentence was, or at least, maybe he felt like something more was appropriate, but he was going to do all he could do. So count one is the malice murder. The other counts, which are the ones that are vacated, and we'll get through those, but that's when you get into the felony murders. There was alternate ways of charging the death, the criminal homicide. So in the event that maybe a juror or the judge didn't believe that he had malice aforethought, as we say in the law, then clearly there would be an alternative way of getting to the same place, and that's this life sentence without parole. But when he says these counts are vacated, what that means is that not that anybody's innocent. It means that you can't be sentenced for all of you can't be convicted or sentenced for more than one killing, out of the same incident. If there were multiple victims, you could, but with one victim, there can only be one sentence. And so by operation of law, these other counts have to be vacated.
Operation of law, count three, vacated. By operation of law, count four,
Felony
vacated
murder.
by operation of law. Count five, life in prison consecutive to count one.
That's going to be the kidnapping with bodily injury. So that's what we'll call a capital offense, meaning it carries with it up to, life in prison. There is no life without parole for that particular criminal statute, but there is a life sentence. So he just imposed a second life sentence consecutive. Now, obviously, if someone dies in prison, they're never going to get around to serving the second life sentence, but it's symbolic. And it's the judge doing what he can, as best he can, to send a message to the family and the community that, this is his intention, is that this person never breathe free air again. But the kidnapping, by the way, it's not the kind of thing where you think of where somebody takes the Lindbergh baby and takes them and holds them for ransom. This is when you take someone, restrain their freedom of movement, and there has to be something called asportation. That means movement. And you can take somebody and physically move them 1 inch or a few feet or several feet, as was the evidence in this case. And that act of moving them against their will constitutes the offense of kidnapping under Georgia law. And of course, if there's serious bodily injury, and we know that there was, that's what makes it, the kidnapping with bodily injury, where the life sentence is available to the judge. And he did impose it. He imposed it consecutive, means it's stacked end on end.
Count 6, 20 years to serve consecutive to count 5.
All right, so this is, I think, aggravated assault. If you assault someone with a deadly weapon, like a rock, or with the intent to sexually assault them, among other things, that's what we call aggravated assault, as opposed to a simple assault. So that was what the evidence was in this case. And so the maximum penalty for aggravated assault is 20 years, and he just stacked that on top of the other consecutive life sentence. So now we're at life plus 20, I think, if my math is correct.
Count 7 will merge with count 1.
So when you have an aggravated assault, that, like with the deadly weapon, if that's the way that you went about the taking of a life, the aggravated assault is it's sort of subsumed and incorporated and merged into the count 1, which was the malice murder. That's what he's referring to here.
Count 8, 12 months consecutive to count 6.
That would be, I think, the hindering of the 911 emergency call. It's a misdemeanor. 12 months is the maximum you can get. And he stacked that on top of everything else.
Strike that. 12 months, but I don't want it to 6. It's just going to be consecutive.
Yeah, he's making sure that the paperwork is worded so that everything is consecutive.
Count 9, 12 months consecutive.
That's going to be the tampering with evidence, another misdemeanor. The maximum penalty for any misdemeanor in Georgia is 12 months in jail. There you have it, consecutive to everything else.
Count 10, 5 years consecutive to count 6. So that would mean the misdemeanors would come after the felonies. That will be the sentence. Mr. Ibarra, I will advise you that you have 30 days from today to seek any post-judgment relief.
All right, so anytime you're going to file what's called a direct appeal in Georgia, you've only got 30 days. Well, there's no way that you're going to get the entire record put together. And by that, I mean all of the motions that were filed, all of the transcripts from all the pretrial hearings. There were motions to suppress evidence and other things, lots of expert testimony related to DNA. And then you got, of course, the transcript and the record of the trial. And there's just no way that all of that is going to be able to be assembled. The transcript's not even ready yet. There's no way for a lawyer to, of course, look at something that hasn't been put together yet to decide what the grounds might be potentially for any appeal. And so as a practical matter, that 30 days, nobody ever files a direct appeal from a criminal conviction. What they do is they file a motion for new trial. Now, stand by, I'll get back to that.
Form of a motion for a new trial or appealing this case directly.
All right, so there's not, you're not going to be able to do, as a practical matter, there's not going to be a direct appeal. What there will be is there will be a motion for new trial. So, look, there's no, in my opinion, there's no reversible error that occurred here. This case will, I'm sure, stand on appeal. All criminal cases have to go through the appeals process unless the defendant for some reason waives any appeal, which I don't think is very likely. It's very unusual. The appeal will happen. So the way that it works is that another attorney, or maybe more than one, in this case, it's going to be appointed by the court, because probably the public defender's office will do it. But you have to have a separate lawyer that looks at all of everything in the case to decide if this lawyer, he or she, might believe there's reversible error. But one of the things that they are obligated to explore is whether or not any criminal defendant had what's called effective assistance of counsel. The Sixth Amendment guarantees everybody the right to a lawyer. And so by extension, if you have a right to a lawyer, that means you have a right to a lawyer that is effective. It doesn't mean perfect. It doesn't mean you have a right to a lawyer that's guaranteed to win the case. But if you have a right to a lawyer, and look, if there were no defense lawyers, this process, or any process in any trial, you wouldn't be able to necessarily trust the outcome. That's why we have an adversarial process. The evidence was overwhelming. The defense in this case, in my opinion, did a good job with a very bad set of cards that they were dealt. They did not have a defendable case, but we must go through the process. It's due process of the law. It's what's required by the Constitution. It's what's required by the laws. Okay, and so is the appeal. That's part of due process. You have the right to one level of direct appeal. And in Georgia, all murder cases skip the Court of Appeals and they go directly to the Georgia Supreme Court. So that's where this one is going. Let's dip back in and listen to more of the judge.
If you make a motion for a new trial and that is denied, you have 30 days from that date to file your first appeal.
All right, so more on the motion for new trial. Procedurally, here's how it's going to work. The lawyers who represented him at trial, they will file, if they haven't already done it, they will file what we call a skeleton or a placeholder motion for new trial, because you got to get that done within the 30-day statutory time limit. If you don't, you waive it. So if a lawyer misses a deadline like that, then that's pretty good evidence that the lawyer's not doing their job, and that in and of itself could create issues on appeal, like effective assistance of counsel. So they will file a placeholder skeleton motion that just alleges, the defendant's entitled to a new trial for a couple of statutory reasons, probably one page, and that gets filed, and that satisfies the deadline requirement. Then fast forward a number of years to whenever the record is assembled, including the exhibits, the testimony, the transcripts, all that stuff. Then an appellate lawyer can file an amended motion for new trial. You got the placeholder motion that stops that 30-day clock from ticking. Fast forward to whenever the appeal's actually ready, and then they have a motion. It's fine. They amend the motion. They have a hearing. It's going to be in the same court, maybe the same judge. If he is still on the bench, it would go to the same judge, and you would say, "Look, Judge, we want a new trial because we believe the following errors were committed." And the lawyers, you heard me in the intro, an interview I did on Fox News, I talked about, we don't know why they waived jury necessarily, but we will find out. And so it's at that hearing where we will find out. We will hear these lawyers testify under oath. They will actually be witnesses for the state, because the state will be attempting to protect the conviction. So they will defend the motion for new trial. One of the ways they will do it is just an evidentiary hearing. You get the lawyers who made this decision, you get them to come to court, and they will testify that they had some legitimate strategic reason for doing this, and it was a matter of trial strategy. And if it's a matter of trial strategy, and if it doesn't work, that doesn't mean that it's ineffective assistance of counsel. That's just like a quarterback that throws an incomplete pass. They had a really good reason for throwing that pass. It just didn't work out. but there has to, if there's a legitimate basis, a reasonable, tactical, strategic reason. And look, you could say, yeah, I mean, I can think of one. You can say, well, my strategic reason was that I knew that the evidence would be very emotional, and we felt like a jury might be overwhelmed by emotion and might make a decision on guilt or innocence on the basis of that emotion and not on the basis of the evidence, whereby a judge who hears and sees criminal cases all the time may not necessarily have that visceral emotional reaction to the evidence. So maybe that's the strategic reason. I don't know. I'm guessing. I'm just saying that that's one that I can think of. If you can think of one, great. I'd love to hear about it. But the bottom line is that in the future, these lawyers will come to court and they will explain their decision to waive jury. I'm sure they've got a good reason. These lawyers were very good. They did a good job with what they had, which wasn't much. The evidence was overwhelming. So don't interpret any of this to be some kind of commentary on the lawyering in the case. We need and we want good lawyers on both sides of cases. If you don't have good lawyering on both sides of cases, there's a few other cases in Georgia we can think about, maybe in recent history, maybe some that are ongoing right now. Okay, you want good lawyering on both sides of the case. That way, you can have confidence in the result. If there's a conviction, you can believe that the jury or the judge got it right because the lawyering was good on both sides. If you don't have good lawyers on both sides, you don't necessarily have a result that you can trust. And we want to have history. We want history to look back on this case and say, the judge got it right.
First level of appeal, court will appoint a lawyer to represent you if you cannot afford one. I'll also advise you that you have 4 years from the date that your conviction becomes final in order to file a habeas corpus petition.
All right. Without getting too deep into the weeds here and belaboring the point, habeas corpus is a special kind of an appeal. It's what we call a collateral attack. So the motion for new trial, and then, of course, I'm sure whenever they get around to that hearing, the judge will deny the motion for new trial. That denial is what gets appealed directly to the Supreme Court. There's another kind of appeal that runs sort of parallel. We call it a collateral attack, where you make a claim under the Georgia state law, and there's also one that you can make later called a federal habeas, but you're alleging certain constitutional violations, and there's a limit on that. It's 4 years, and so you can't bring that collateral attack. The judge is admonishing him of all of his appeal rights, which is what the judge is required to do. So that's what he means by the 4-year habeas.
Mr. Donnelly, can you tell me, are you all going to be involved in the next stage?
That remains to be seen, but my understanding is that we will remain on at the court's appointment until unless relieved by conflict counsel.
All right, so these are public defenders. They work for just like the prosecutors, they work for the government. Their job is to defend indigent people. So what he's saying, the judge was asking when he says, are you all going to stay involved? He's meaning the public defender's office. And if I understood this lawyer correctly, what he's saying is they're going to stay involved in it until somebody else does, just as like a placeholder. But because of the fact that they eventually are going to be witnesses at the motion for new trial several years in the future, these lawyers can't do the appeal. It'll have to be somebody new with a fresh set of eyes who can look at what these trial lawyers did. You've got to have another set of eyes to sort of double check your work, so to speak, to make sure that there's no issues of ineffective assistance of counsel.
All right, and you'll make those arrangements.
We will communicate that with Mr. Ibarra and with the court.
Okay.
Yes, sir.
All right. Anything else, Ms. Ross?
No, Your Honor.
Okay. It's going to take a little. Can we take the?
We're going to move and then we can go down to the same side.
Okay, that'll be fine. Can do that.
Everybody remain seated, please.
All right. So that's it. It's my understanding that Ibarra has already been sent to the state prison system, which is not uncommon with high profile cases, particularly ones where, look, let's just put it this way. The local sheriff doesn't want him in the jail there any longer than is absolutely necessary for this trial. I think before the ink was even dry on the sentence, they may have actually had him already transported to the state. He goes to probably to a place called Jackson, Georgia, where it's called the Diagnostic and Classification Prison, where they do testing and they determine what level of whether it's maximum security or whatever, and then from there inmates go to some permanent location. I want to get into this. I mentioned earlier we talked about why the death penalty was not on the table in this case, and one thing that I want to let's see if I can share this with you. This is a memorandum that was sent to assistant district attorneys and staff in the Western Judicial Circuit. That's the counties of Athens, Clark County, and next door in Oconee County. 2 counties make up this judicial circuit, from DA Deborah Gonzalez. Okay. And the subject of this is fairness and equity in the Western Judicial Circuit DA's office. Now, what I can tell you is, fast forward a couple of years, I think some of this memo may have been modified or even withdrawn, because she came under fire for essentially plagiarizing this almost, I guess, verbatim from other people call them Soros type DAs, and I think that probably fits here. But she goes on to lots of things, and she points out that like she gets into the current bail money system. She doesn't like people having to post bail. The DA's office will recommend defendants charged with nonviolent offenses should be released on their own recognizance bonds. They will recommend that people charged with violent offenses not involving actual injury, violent offenses will be considered for own recognizance bonds. They will recommend that defendants charged with violent offenses in the nature of threats will be presumed eligible for their own recognizance bonds. So people who are charged with verifiable threats are presumed to be eligible for what's called a signature bond, where you just sign your name and you walk out of jail. In any event, she goes on to point out this office will no longer seek the death penalty, period. She will not seek the death penalty, and under any circumstances. And she goes on to say, cases which are legally eligible for the death penalty are eligible for sentences of life without parole and life with parole eligibility after serving 30 years. Both of these sentences constitute very substantial punishment. Decisions to seek life without parole are a sentence of death in prison. So decisions to seek sentences of life without parole must be made by the DA. That means herself personally. She's not going to let an assistant DA make that decision. And this is all out there. It's public record. I think I posted it on X in its entirety yesterday, so you can check that out and read it all for yourself. But this is look, at sentencing, the assistant DA will submit to the court an economic impact statement. This statement will include the costs of taxpayer incarceration or probation supervision. The DA's office believes these costs are appropriate when balanced against the benefits, basically, of incarceration. So I've never seen any prosecutor at any sentencing ever submit this kind of document to a court. It's to say that it's just, it's just very unusual. It's not the norm. It's kind of absurd, honestly. everybody knows that it costs money to prosecute cases. It costs money to run the jails. That's kind of already baked into the cake. But in any event, this is the, here you go. This office will take into account collateral consequences to undocumented victims, such as Ibarra. I'm sorry, or witnesses. He's not a victim, so I will defend it. But what she says here is she'll take into the collateral consequences of undocumented victims or witnesses when deciding how to present a case. In other words, they're not going to subpoena people to come to court if they might not be in the United States legally. That's what that means. She goes on to say, all kinds of things. She's going to release to the public dash camera. All evidence, audio is required, permitted by law. So, I mean, there are some parts of this that kind of make halfway sense, but on balance, let's just say this memo did not go over well with many in the community, and it suggested that she was going to make decisions that were based on things that were not the norm. She's using things other than traditional prosecutorial considerations. Let's just put it that way. All right. Look, this case, guys, was one of the most emotional and horrifying cases that I've ever witnessed. It's just absolutely heartbreaking. History will decide whether or not justice was served. You can decide whether justice was served. Do me a favor. Tell me what you think. Put in the comments, either in the live chat or in the comments to this video. Tell me, do you think that this was justice in this case? Or should there have been something more available to the judge when he imposed his sentence? Tell me what you think. And look, if you find this content interesting, if you think that you can learn something here, do me a favor. If you haven't subscribed, please subscribe and tell your friends and your family and anybody you know who might get benefit from learning about the real justice system. Have them subscribe here Inside the Law. And we will continue to monitor cases as they move forward. I will say, by the way, I was planning on in the next week or so doing a live stream. I was going to cover the oral arguments for the Fannie Willis versus Donald Trump and others, the racketeering case. Ashley Merchant and crew were going to argue to the Court of Appeals why Willis should be removed from the case. But surprisingly, just the other day, the Court of Appeals decided that they were going to cancel the oral argument. Now, we don't know why. I posted about this as well on X. And I believe that the reason that they canceled is they're going to rule against Willis on the basis of the briefs. I was going to do a live stream about that. We're not going to have that live stream anymore because that oral argument is not going to happen. But my point in all this is that we're going to continue to cover the legal cases that are in the news. We're going to use those as opportunities to learn something about the real justice system and what we can learn about that justice system from the cases that are in the news. All right. Well, look, I appreciate everybody. I'm going to have to leave it there for this special edition of Inside the Law. Do me a favor, like and subscribe to this channel and this video and follow me on X. And until next time, I'll see you here Inside the Law.